The next case is for a tennis player. It's a 10th case from February, and had two interesting points in it. First off, it's not part of the interesting points, but they got the lesser awards and published material, which usually for a top athlete is pretty easy because the athletes are competing, so they do win awards and they have articles written about them. So they knocked those out. But then they try to get the third one with membership in associations or leading or critical role. And so when you go into membership associations, they go into the fact that their petitioner claimed that the director failed to follow USCIS policy, knowing that the election to a national all-star or Olympic team might serve as comparable evidence for evidence of memberships. So in the memberships analysis, they use a qualifying national expert in the field on a road, but they didn't really buy it or affirm it. And what is important here, I make this argument a lot for my sports players that if they're part of the national team, their memberships in top organizations. And a lot of times we don't get a decision on it because it just gets approved. So it's like they don't, even if it's not accepted, they don't get into it. But here they're saying, okay, we're going to use comparable evidence to get this one in, and they're saying the six USCIS policy manual F2B1 comparable evidence. She also cites a 2023 non-precedent decision bar stating, given the level of accomplishment required to secure a place on a country's national team, which competes at an international level, it appears reasonable to conclude that it is the functional equivalent of an associate of the type contemplated in the regulation association. So it's, I guess they're arguing membership, but at the same time, they're saying comparable. USCIS policy, however, did not require the director to accept the petitioner's membership on the blank national tennis team as comparable evidence of her membership in a qualifying association. The policy states only that election to a national all-star team might serve, quote unquote, might serve as a comparable evidence. Also, our non-precedent decision does not bind us in this matter. And then they go here. Further, USCIS considers comparable evidence only if a regulatory criterion does not readily apply to the petitioner's occupation. So that's petitioner's occupation is really important there. The petitioner has not demonstrated or even asserted that the membership criterion does not readily apply to tennis players. See Guido B. Miller, number 20 CV 01471LB 2021, Westlaw 5 or WL 568850, North California, February 2021, affirming USI's decision that before the agency can consider comparable evidence, a petitioning formal national team coach had to demonstrate that the criterion of 8 CFR 204.5832 did not apply to his occupation. So that's for the comparable evidence aspect. If you're going to argue it, you got to knock it out of any of the 10 criteria to be able to get into that one. So that was really an important pickup from this one because sometimes you just shoot out the comparable evidence, but you got to make sure it doesn't fall